Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hope you guys had a Merry Christmas. Who? All right, so I don't know if y'all have heard, but this is breaking news. Jay-Z has been defeated in court, and I kind of figured this was going to happen. But the judge gave Jay-Z a beautiful present the day after Christmas. More like a late present. All right, so we're gonna hop right on into this. So Judge Torres, Annalisa Torres, has put out her order. So pretty much she has remained silent since the what's up, Hey Rita. Hey Rita. Hey, I do not know how to say your name. I'm sorry, but hello. Um, so she has since Tony Buzbee has amended this complaint to include Jay-Z on it. Um, like all that matters is what happens in court. That is correct. That is correct. Um, so Jay-Z, we know, has been filing response after pleading, so on and so forth, trying to throw Buzbee off, and Buzbee fired back, and the judge really has been very ooh, Maddie, academic. Oh my gosh, I'm about to be pissed. Oh my gosh. Okay. I'm gonna look at to that. I've been chilling, y'all. I've been doing some work and watching Netflix and everything. So I've been and it's raining in Dallas. So I've been straight chilling. But I'm gonna look at that, Maddie, because I am upset. Like I said before with the DJ Academics case, attorney Tyrone Blackburn, the same one who is in cahoots with Dwayne Youngblood, who has filed a lawsuit against Bishop T.D. Jakes, and Tyrone is actually on another Diddy case. As a plaintiff's attorney, so he has some shady dealings. But I'm definitely going to look at that once I finish with this one right here. Hey, Jennifer. Yes, I hope everybody had. Okay, Maddie. I was about to say, I may do another live and we can go over DJ Academics, but I usually check his periodically and I don't see anything that has happened, but I will definitely do an update on that. So hey, thank y'all for tuning in. Thank y'all for tuning in. So like I said, Judge Torres has been quiet, and today she dropped an order that pretty much we're gonna get into because I don't want to spoil it for y'all. But so far, we know, and here's the timeline. Buzbee amended the complaint to include Jay-Z. Jay-Z filed a response. Well, he didn't even file a response. He put up a statement before he was even served, talking about I ain't giving them one red penny, and that wasn't even the case. They just asked for a confidential meeting, and here you are talking about people asking you for money, and that wasn't even the case. And then he's trying to throw out there that Buzbee wasn't even admitted to the Southern District of New York, and the plaintiff need to tell us who she is, all of this crazy stuff. And Judge Torres has been quiet, but today she letting us know what her ruling is on everything Alex Spiro and Jay-Z has filed. Let's hop right on into it. All right. So I hope y'all guys the day after Christmas, so y'all better get y'all eggnog, your tea, your coffee, your water, whatever. So let's hop into it because I don't be keeping up with celebrity stuff, but I know that um Beyonce had a little show out here in Texas, I guess for the was it for football, I believe, and they said Jay-Z was nowhere to be seen. I seen that all over social media. I was like, "Ooh, child!" Oh, thank you for becoming a member. Thank you. Welcome. All right, so let's hop on to it. I don't want to further delay this. So, plaintiff Jane Doe filed this action on October 20th, 2024, alleging violation of the New York City Victims of Gender Motivated Violence Protection Act NYC Admin Code Section 10. 1101. Generally, okay, and now when it says the ECF number 1, that is just the docket entry. So this was the first docket entry on this case. By order dated November 6, 2024. The court provisionally granted plaintiff's motion to proceed anonymously, explaining that defendants had yet to appear in this matter and that the balance of interest weighing for or against anonymity may shift as her suit continues. So they're saying when Jay-Z was amended and he came out and he demanded for her identity to be revealed, there was already an order stating that she can proceed throughout this case, under the pseudonym Jane Doe. Okay, so I don't even know why Jay-Z thought he can change something, but it does say that they explained that the defendants had yet to appear in the case and that the balance of interest weighing for or against her proceeding under the pseudonym may shift as her suit continues. So it just depends on the suit for the court to determine whether or not she has to reveal her identity. But as of right now, they're saying no, she can continue under that pseudonym. All right. On December 8th, 2024. What's up, top 20 Louisiana Law? Hello, everyone. I hope everyone had a wonderful Christmas. I'm on a diet because I ate so many delicious food. Hey, look, I kept it simple. I made some steaks, some pinto beans, some rice, and that's good enough because I didn't want no more Thanksgiving food. All right. So on December 8th, 2024. Plaintiff amended her complaint to add Sean Carter, known professionally as Jay-Z, as a defendant. And then it says amended complaint. Plaintiff again sought leave to proceed anonymously. But this time, Carter's counsel appeared and moved to deny her motion or, in the alternative, to dismiss her amended complaint pursuant to Federal Rules of Civil Procedure 12B1. Then it says Carter also moved for an expedited hearing on the issue. Y'all remember that? The next day, Carter's attorney filed a letter containing a declaration from an associate at his firm recounting a phone conversation she had with an unnamed woman who claimed plaintiff's counsel encouraged her to lie about her experience of SA. Y'all remember that? Carter's lawyer asked the court to consider this additional information in connection with plaintiff's motion to proceed anonymously. Plaintiff counsel denied Carter's allegation against him. On December 13th, Carter's attorney filed an additional letter alerting the court to a recently published interview of plaintiff on NBC News. It just looks like whatever happened is like they went back to go tell. You know how when something happened, kids come and tell you stuff? This is exactly what they were doing, except in filings. In the interview, plaintiff, speaking anonymously, explained her allegations against defendant and her reasons for coming forth. Carter's lawyers points to the interview in which plaintiff admitted to inconsistencies in her story as evidence that plaintiff's claims have no factual basis whatsoever. He also argues that plaintiff's counsel violated the Federal Rules of Civil Procedure 11B by failing to undertake a reasonable inquiry into the facts before filing the complaint and failing to seek admission pro hoc vice to this court. Carter's attorney requested an expedited briefing schedule for a motion to strike the First Amendment complaint under Federal Rules of Civil Procedure. All right, the next day, Carter's counsel submitted yet another filing, a motion for an emergency order directing the preservation of evidence and striking the amended complaint under Rule 12. All right, let me see. Susie says she should be made to reveal her name. When Buzbee went for Deshaun Watson, the lawyer rounded up a lot of women that caught lying. Y'all have to understand that these are separate jurisdictions. All right, these are separate jurisdictions. What they do in one jurisdiction is not going to happen in another jurisdiction. When you so I don't know if Deshaun, I don't know that case personally. I don't know if that was in state court or in federal court or in Texas or in New York. So what you will see happen in one jurisdiction, it does not mean that it's going to happen in another jurisdiction. So we do have to keep that in mind. Happy New Year, Buttercup. Maddie said, do you think that if she has to give her name, that she should only give a picture of her at age 13 or her age at the time of the assault? That's a very good question. I don't know. Probably, like it said in the beginning of the letter, as the case progresses, it may be a possibility that her identity will have to be revealed, but I have no idea. See, okay, so that's Texas. See that this is Texas. So what that case that you were saying was in Texas. We're dealing with the Southern District of New York. So they have had so many cases to where there are a lot of people that use pseudonyms John and Jane Doe for SA cases, and even with the uh cases where they were abused as a child. So there was something that I read in my last live, I believe, regarding this, that shows how some judges did rule as far as an individual still continuing to be under that pseudonym. So it's all based on the nature of the case and the parties and whatever that jurisdiction is. So we can't compare the Southern District New York to, the Southern District of Texas. It doesn't work that way. That's why federal judges control their own district, and they have their reasoning as to why somebody can continue to be under a pseudonym, or if they have to reveal themselves. Y'all have to realize that's the whole purpose of being a judge. The judge are to interpret the law and apply it based on that particular case. So based off of this case, the judge feels, and I'm gonna shut up and I'm gonna continue to read because it's gonna break down as to why she gets to continue under the pseudonym. So it says motion. Let me see. Susie, okay. Thank you for the explanation. Why is her father's story not lining up with hers? I just think they shouldn't let people be anonymous. Anyone can make on the claim. And that is correct. But and this is the reason why we have to read case law. Not everybody's not going to do it, but if you're in the legal field, you have to read case law, and you have to have other cases that you can cite to support your claim, because it just depends on the situation. It depends on a lot of things, and that's why judges are in the position that they're in, because they can interpret it, and then they can also apply it, and they can explain why they applied it this way. All right. So here's the reason with the motion. Well, not the reason, but they're talking about the motion to proceed anonymously. All right. So it says, in deciding whether a plaintiff may proceed anonymously, courts balance the plaintiff's interest in anonymity against both the public interest in disclosure and any prejudice to the defendant. So they did cite it, sealed plaintiff versus sealed defendant, where it's, and so they used this case and they broke down as to why the client gets to continue under the pseudonym Jane Doe. Let's talk about it. So the Second Circuit has laid out a non-exhaustive list of factors to be considered. So these are factors that is telling us the reason as to why the court is going to consider for her to remain under the pseudonym Jane Doe. One, whether the litigation involves matters that are highly sensitive and of a personal nature. Whether identification poses a risk of retaliatory physical or mental harm to the party seeking to proceed anonymously, or even more critically, to innocent non parties. Y'all have to keep in mind, of all the things that have transpired, we have seen investigators, we have seen this who is it, I call her private investigator Jessica Santiago, and MG, what is it, MG or MJ? MJ Legal, where that Marty or something Croft, I forgot her name already, who's working with Rock Nation. So they're doing little things on the outside to intimidate even, people that Buzbee are associated with. So who's to say that if her identity is now revealed, that they won't do the same thing to her and her family? So this is what the court is considering. All right, 3, whether identification presents, oh, did I already read? Yeah, I already read. Did I read that? Whether identification presents other harms and likely severity of those harms, including whether the injury litigated against would be incurred as a result of disclosure of the plaintiff's identity. 4, whether the plaintiff is particularly vulnerable to possible harms of disclosure, particularly in the light of her age. 5, whether the suit is challenging the actions of the government or that of a private party. 6, whether the defendant is prejudiced by allowing the plaintiff to press her claims anonymously, whether the nature of that prejudice, if any, differs at any particular stage of the litigation, and whether any prejudice can be mitigated by the district court. 7, whether the plaintiff's identity thus far been kept confidential. 8, whether the public's interest in the litigation is furthered by requiring the plaintiff to disclose her identity. 9, whether because of the purely legal nature of the issues presented or otherwise, there is a typical weak public interest in knowing the litigants' identities. And 10, whether there are any alternative mechanisms for protecting the confidentiality of the plaintiff. So, let me see. A court is not required to list each of the factors that I just read or use any particular formulation as long as it is clear that the court balanced the interests at stake in reaching its conclusion. Here, the weight of the factor tips in favor of allowing plaintiff to remain anonymously, at least for the stage of the litigation. So I hope everybody understands that part, because remember at the beginning of the letter they said that they have to it just depends where they're at in the litigation, but it might change later on. So here the judge is telling us that what I just read out of this list, they says that the way of the factors tip in the favor of allowing the plaintiff to remain anonymous at this particular stage of the litigation. Right now, we are in the beginning discovery phase of the litigation. That is where we are. Now, after, let's say, after depositions, after discovery, they head on into mediation, that may change. Or if they don't do anything at mediation and it possibly has to go to trial, that may change. But as of right now, during this stage of the litigation, the judge is saying some of the factors that I just read lean more in favor of the plaintiff to allow her to remain anonymous. All right. And then he breaks it down. Hold on, I'll read that in just a second. The mistake that jayz lawyer made was rushing the process. His attorneys came across as cocky. They would ultimately get thrown out later on. A sad situation. It is sad. But if we look at and I see this all the time, and I've said this in the beginning, you have to look at how they came in. Like jayz putting out a statement before he was even served. Like all of these little things is making you look guilty. Okay. It's proof that investigators are going out on their behalf. Firms are going out on their behalf and, trying to intimidate people. It's not looking good at all. And I'm pretty sure the judge took all of that into Her name can't be hidden forever. We will all find out. So no, and that's what this is saying. So as of right now, during this stage, her name is going to remain anonymous until, and that may change. Can't sit through this too long, drawn out. Get to the dot. Oh, girl, you could go. Jessica H. I agree. I even if she has. What's up, MEP? Yes, the deposition is everything. It is. It is. It is. It is. What's up, Gratefully Living? MEP, you that's what I'm saying. That's what I'm saying. Hey, look, what I'm gonna do, everybody talk about get to the docs. I'm gonna read this. If you want to go somewhere else, that is totally fine. But when I read these, I want to make sure that everybody understands. I don't want to just sit there and read and then have to go back. No, I'm gonna break it down as I read, respectfully. All right. Okay. So all of the factors that I just read there, that he's well, not he, I'm sorry. Miss Torres actually tells us what factors she used. So she said 1, 2, 4, and 7 weigh strongly in favor of anonymity. In her amended complaint, plaintiff alleges that defendants rugged and raped her when she was only 13. Courts in the district have recognized that allegations concerning SA are highly sensitive and of an extremely personal nature. All right. So, whether litigation involves matters that are highly sensitive. So, what constitutes as highly sensitive? She says right here, the plaintiff alleges that she was rugged, raped when she was 13, and they recognize that SA are considered highly sensitive and personal in nature. All right. All right. Good. Yes. Thank you, Susie. Thank you, Susie. Yes. MEP, you hey, y'all, MEP up in the chat. She'll tell you to run up out of here. This is for those who want facts. Exactly. Judge I keep saying her name wrong. Torres is also establishing that she has control of her court, not the play. Exactly. Exactly. Like, because the way that Alex Spiro was filing these is like, oh, I want the judge to react to this, this, and this. And that's not going to happen. That's not going to happen at all. Let's see. All right. So where was I? Okay. Plaintiff is particularly vulnerable to the possible harms of disclosure. Sealed plaintiff states, according to her amended complaint, she continues to experience depression, post-traumatic stress disorder, and a seizure disorder associated with the stress of her SA. All right. So that's one factor that judge used. Let's see. Moreover, plaintiff counsel asserts that many of his other clients who have filed similar lawsuits against Sean Combs claim to have been threatened by Mr. Combs for their decision to speak out. Because y'all have to realize this is not just against Jay-Z. This is also against Diddy. This is also against the other people that are included in this particular suit. So therefore, she can't just say, "Oh, you have to make sure, not make sure, but you have to come out because Sean Carter said he requested." No, she has to take in consideration all the defendants that is included in this lawsuit. Then it says, and finally, although plaintiff sat for an interview with NBC News concerning her case, NBC allowed her to conduct the interview anonymously. All right. So all of the things that Jay-Z and his attorney tried to put out there and said, oh, she did this, X, Y, and Z. She needs to go ahead and reveal herself. The judge says no. So she took the factors and she applied it to this case. That's how it works. That is how this works. What's up, Gold Digger? Hey. Yes, y'all don't forget to like, share, and subscribe. Definitely comment. Definitely comment. Jessica H says at Susie, and that's why he's innocent until proven guilty, and she's a victim until proven to be an opportunity. But this was the lifestyle of most of that lifestyle back in the days, to be honest. Yes, Merry Christmas. If I hope that each and every one of you had a Merry Christmas. All right, so let's get back into it. All right, granted, several factors weighed against allowing plaintiff to proceed anonymously. Plaintiff is challenging the actions of private parties, not the government, and given the media attention surrounding this case, the public has a substantial interest in this litigation, separate and apart from its general interest in the accused being able to publicly confront an accuser. Let's see. Alternative mechanisms may exist to protect confidentiality, namely the redaction and sealing of documents. Most importantly, plaintiffs' continued anonymity. I get that word mixed up all the time, may cause prejudice to defendants, making it more difficult for them to collect the facts necessary to mount a defense and, as appropriate, challenge plaintiffs' credibility. They cited Combs. I don't know which one this is, but it says identifying the most significant form of prejudice to defendants as discovery disadvantaged the plaintiff anonymity which would present. The court does not take such prejudice lightly, because if they come out right now during the discovery phase and reveal her, it's not going to, and I'm not, benefit is probably not the correct word, but you want both sides to have an opportunity to be able to, defend themselves for the defendant, and obviously for the plaintiff to bring out the facts and present her claims in the burden of proof. Nevertheless, at the exceedingly early stage in this case, the factors counseling against disclosure outweigh those that counsel in favor. Accordingly, plaintiff's motion to proceed anonymously is granted. Plaintiff is advised that because the balance of these factors will certainly shift as this case proceeds, especially if and when the parties engaged in discovery in earnest, the court intends to revisit this decision at a future date. So everybody understands. So Buzbee's motion for Jane Doe to continue to use the pseudonym Jane Doe, it is granted. But the court can revisit this at a later time to determine if she needs to reveal her name. Susie said, "I'm sorry, but she's saying people were there that weren't. Her father doesn't remember her story. I guess I just don't care for Busby. He's something else when it comes to cases like this. He is, but he's an awesome trial attorney. I guess because I work in the field, I'm just like he's awesome. But what I try to tell people is take your feelings out for either party and just look specifically at the law. And that's what judges do, because if they use their feelings, if they put their feelings in it, oh, I don't like jayz, or I think that this person lying, they wouldn't be a very useful judge. Because like I always said, judges are there to interpret the law and apply it as needed. All right, so now we're going to talk about, so that was the first motion, and that was filed by Buzbee. Now we're going to talk about all the other motions that jayz filed. So it says, since Carter's attorney first appeared in this case 17 days ago, he has submitted a litany of letters and motions attempting to impunge the character of plaintiff lawyer. Ooh, many of them expounding on the purported urgency of this case. Baby, I love it already. This judge about to let him have it. Oh, let me see. Let me see. So I guess the filing at 38, it says describing plaintiff's counsel as self-promoting and accusing him of extortion. Then she also quoted in another filing requesting to be heard on an expedited basis and accusing plaintiff's counsel of exploiting the legal process to generate media attention. Then she also quotes another filing where let me see, where Spyro says plaintiff counsel seeks to only benefit himself. The judge also quoted requesting the shortening of a deadline from 21 days to 1 day. What else she quote? Describing plaintiff's counsel as willing to blatantly violate the core ethical obligations of all attorneys and requesting a hearing on the motion the following day. Baby, that judge went through all them letters and she pointed them out. So let's hear what her response is. Carter's lawyers' relentless filing of combative motions containing inflammatory language and ad hominem attacks is inappropriate. Look at this. Look what the judge said about all these filings. She said it is inappropriate, a waste of judicial resources, and a tactic unlikely to benefit his client. The court will not fast track the judicial process merely because counsel demanded. I'm about to say drop mic and walk off. What I tell y'all? He's just filing. Like, that's what I'm saying. Jay-Z is sitting up here demanding this, and this, and has no power. Has no power whatsoever. The judge sat right here and said it's inappropriate. It's a waste of judicial resources. It is a tactic that is not going to benefit Jay-Z. And on top of that, you ain't going to tell me to fast track nothing because you demanded it. Okay? Go ahead, Miss. Go ahead, Miss Torres. I like her. I really do. I like her. Moreover, although Carter's attorneys assails plaintiff's lawyer as having a chronic inability to follow the rules, as he stated in one of his filings, Carter's counsel has failed to abide by this court's clear rules. What I tell y'all the other day, the pot calling the kettle black. So while Alex Spiro is sitting here trying to say, oh, Buzbee ain't following the rules, the judge just said, you ain't even following my rules. Under the court's individual practices in civil cases, and with limited exceptions, a pre-motion letter is required prior to filing any motion. Although Carter's attorney stated that he intended to file immediately a motion to strike the First Amendment complaint under Rule 12F, as he stated in one of his documents, he did not give plaintiff the requisite 5 business days to respond, because you have to let them know that you're going to be filing a motion. And it says 5 business days. You have to allow them 5 business days to respond before you try to file anything. Mm, 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 mm. Let me see. Oh, let me reread that. Da, 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 da. Okay. So although Carter's attorney stated that he intended to file immediately a motion to strike the First Amendment complaint under Rule 12F, he did not give plaintiff the requisite 5 business days to respond, wait for the court to set a motion schedule, or state whether an exception to the court's individual practices applied. This is unacceptable. And I'm going to read the footnote. Footnote 2 says, on the merits, Carter's motion to strike is denied. Motion to strike under Rule 12F are generally disfavored and will be granted only if there is a strong reason to do so. Carter's motion was, which summarily asserts that plaintiff's claims are baseless and salacious, does not clear that high bar. Counsel is hereby advised that any further motions filed in violation of the court's individual practices may be denied on that ground alone. I'm gonna tell y'all something. Any jurisdiction that we work in, like I said, each court has their own local rules and procedures. If you do not abide by that, you can mess up your case. So for the attorneys, any jurisdiction that we file in, that they file in, I make sure that I pull the court's local rules and procedures and I save it to that case. So that way they know and I know once I am filing that I am doing it correctly. Because you don't want to get embarrassed like Spiral's getting embarrassed right now. And that's what's happening right now. He's getting straight embarrassed. Oh, he's about to be humbled and is hold up. Oh, let me go back. Um okay. So this is where Cassandra, just remember to say Anna first. Okay, Miss Anna, Miss Judge Anna Torres. uh Thank you for the support. Yes, y'all definitely support impartial. Gold Digger said, from my understanding, she may have gotten the years mixed up. The people she spoke of being there were actually there a different year. And that could definitely be a possibility. And that's why we have the discovery phase so we can sort all of that out. Autism, age, threats made to other victims. Yeesh. This court will not be fast track not fast track the judicial process. You go, Judge Torres. Yes. All right. All right. Let's see. Jessica said Little Kim sang a song, Lighters Up. She said in the song 12 years old, that doing Lady of the Night activities. She's from Bedstew. That was just the way of life when the flooded be more with I don't know nothing about that. I gotta go back and pay attention to the lyrics. Very true. Christina Farah is playing pity pat at a chess table. The judge makes the rules and not following them could hurt the case and possibly yes, a sanction. That's what I'm saying. I'm baby. No, only pronounce it Anna. Oh, Anna, animosity. Thank you, baby. But let me tell y'all, like, I be tired of reading and typing all day. I was like, look, I am an educator, but I don't know all these words. I'm gonna be honest with you, I don't know all these words. All right. So it says, lastly, although Carter's attorney is entitled to file, so they're saying he's entitled to file a Rule 11 motion without first seeking leave of court. The court discourages this approach. If he still intends to serve plaintiff with a motion for sanctions, the court denies his request to shorten the safe harbor provisions contained in Rule 11C2 from 21 days to 1 day. Because remember, so she's not saying that if he wants to go ahead and file another motion to strike, he can do it, but he can't change the rules. The rules for the safe harbor is 21 days. So he can't be like, oh, he needs to respond in 1 day. No, you have to give them 21 days. Let me see. It says at Carter's motion to strike the amended complaint under Rule 12F is denied by January 10th, 2025. Plaintiff shall file her response to Carter's motion for an order directing the preservation of evidence. And by January 17th, the Carter shall file his reply, if any. So pretty much they have got all of this out the way. Now, she is just saying that Buzbee, the firm, whatever firm, local counsel he's working with in New York, they have to file a response to them preserving evidence. Because remember, I forgot when he's filed that darn motion, but they wanted Buzbee to preserve any evidence that he has. Because if he doesn't, then he's going to get in trouble. So Buzbee has to reply to that by the 10th. And then once he replies, then Spyro has to reply to Buzbee's response to that. And then that's it. So they are moving the case along. So she says the clerk of court is respectfully directed to terminate the motions at ECF. So whatever motions that jayz put out, let me see, that's 32, 37, 40, 41, and 46. That's 1, 2, three, four. That's five motions that have been filed by Jay-Z, and they all denied. I'm not laughing, but it's funny because what did you think you was gonna do? What did you think that you were gonna do? That's it, y'all. That's it on that one. So Merry Christmas, Jay-Z. I know he probably punching the air somewhere right now. I know he is. He has to be. Susie said, "You're welcome. English was my best subject. Love your channel. Love through the love. Thank you, thank you, girl. I hated English, but see, I also teach GED, so I teach GED English, so I have to make myself like it in order to, teach the adult learners. Um, it's there. I just watched the video and read the lyrics. It was just that way back in the day. The neighborhoods were in a hot mess. We're in 2024. Things are a lot very different now. Cassandra, there's a special law in place in New York regarding those who have cognitive disabilities, autism, with the understanding time, dates, locations may not be exact. No, yes, and that's what I was reading in some of those cases because I didn't know individuals who were autistic actually have, a problem with understanding time and date. So that is something that they do have to take in consideration. So during this process, since we are now entering into that discovery phase, this is going to give them the opportunity to work with experts, whether cognitive or whatever they need to do to work with her to actually see um, what happened, try to piece together the timeline, all of that other stuff. So this is the time in which they are going to do that. We may see another amended complaint, and that's okay. That's what we do in the process. Jessica, I looked it up and read them going back after this. Y'all gonna have me going reading lyrics. I'm not a J fan. I stick with the facts, but any billionaire would have done the same thing. It's about defending themselves. I totally agree. I really do. But but I look at it differently. When you are, and I nobody wants to be hit with this type of allegation. You know what I'm saying? So look at when Cassie Ventura, she filed her complaint. Less than 24 hours, they've already settled. Sean already settled with her. And then they try to do some damage control and be like, a settlement is not an admission of guilt. And that's true. However, look how it happened. And yet people still did not believe her until the hotel video came out. So I look at everything, I sit back and I observe, but the way that they did her, I'm not going to sit up here and say that this child, well, she's grown now, but I'm not going to say I don't believe her. I just like to wait during the discovery phase to where a lot more information is going to come out. We're going to see a lot more, well, not a lot more, but the complaint being amended probably one or two times in order to, once they have a recollection and a chronological order or a timeline of events, we're going to see that. So I like to give cases time to develop. But when you start filing all of these, that you can't sit here. Spyro should not have sat here and do the same thing to Buzbee that he's doing to another person in the Eric Adams case. And the court in that case told him off too. So Spyro better, Quinn Emanuel, y'all need to get a hold of y'all boy because it's not looking good. Judge Torres just told him it's not looking good. This is the second judge. This is the second judge. Yes, time and dates are difficult. Even location is difficult for some autistic people. Some can't tell time on the clock. That's correct. That's correct. I have not worked with anyone who has been autistic, but I have a friend. I haven't talked to her in a while whose son is autistic. So I would like to do more research on that, look at journal articles to see, the symptoms of that. The problem is he was defending himself before he was named. Yes. And how can I say this? Because remember, Tony sent the demand letter that they're claiming is extortion letter. And so that's why. And after he received that extortion letter, aka the demand letter, that's when he filed under the pseudonym John Doe. So do y'all believe that it was fair for Jay-Z to file under John Doe? Don't y'all think that he should have filed using his regular name? Dun dun dun. Yes, MEP, not that much different. Some places even worse than back in the day. Oof, yeah. Puff was nasty from the jump. But why is Clive not in court? That's a very good question. Whitney, man, say you on to something, baby. That's why I just said I've always said it is bigger than Diddy. It's bigger than Diddy. It's all about to come out. No matter what's going on, I just want a fair trial. That is correct. I think every party deserves a fair trial. Some attorneys sell their clients' dreams. That's true. I'm gonna be honest. Like the attorneys, they gave me the say so. I'm gonna tell you, you call me and you want an intake done. Guess what? If I feel like your case is not it, it's not it. And I'm not saying it to be mean, but if you don't have all the facts, or there's certain inconsistencies, like I'm talking about like true inconsistencies, something that I know I would not be able to investigate or prove, I'm declining, point blank, period. Now you can go find another attorney's office to plead your case to, but we can't do it over here. So I'm not telling you Jessica. Yes, that is a good question. What's up, Rose and Gold? What's up with Whitney? They are going to have to expose how they why are you barking? With Whitney, they are going to have to expose how they manipulate. Man, that's even deep, because I don't even think the way that she was unalived, I don't even think that's how she really went out. Michael Jackson, all of them. I believe that it's something deeper and we will never know because we're just regular people. Stay tuned. I'm sure there's more to come. What's been hidden in plain sight is going to be revealed in plain sight. Yes, ma'am. Yes, ma'am. Absolutely. Clive is getting ready to have dementia. Baby, dementia, Alzheimer's, all kinds of stuff. Oh man. Yeah, don't forget, y'all. Don't forget to don't forget to hit the like button, and definitely leave a comment, y'all. I love the discussions. I love to, go under the comments and actually have meaningful discussions on this, because I do want to know what you guys' thoughts are. Because, like I said, you don't have to be a fan of Jay-Z. You don't have to believe, Jane Doe, but just thinking of the legal system and the laws, that's what I want to discuss. Because I see a lot of people that will say one thing, but we can't forget what the court, just like how I love how detailed Judge Torres' letter was. She listed out, the considerations, and then she told us what factors applied in this particular case. I love it. I'm actually gonna save that, and I don't know, maybe once I get my law degree and I start teaching paralegals, I might use that. But that was awesome. What's up, Heavy? Hey, happy holidays. I might go back into my criminal. Hey, man, it is so. I told my attorney, because it's not too much for a paralegal, as far as diving into criminal law. So I was like, is there anything I could do? He's like, not much, because with attorneys, they're really, really going to be going into, court. But when it comes to drafting motions and stuff like that, that's what they leave up to the paralegal. So it's not much to do as a paralegal in a criminal case versus a personal injury case and stuff like that. But I love looking into stuff like that. Criminal justice is that's it. Criminal justice and civil rights. I love those. I love to just read on that one. Your favorite product? It's a shakedown. In 20 years, we have it's becoming billionaire. Baby, I already see it. Yeah, I was like, we ain't there. It's 2024, and I always see these ninjas out here becoming billionaires. So I don't think we gotta wait for this. And it may be a shakedown. It may be. We never know. The only thing that we could do is just really wait and see what comes out. When I tell y'all discovery, the discovery process is going to take a couple of months, depending on how much discovery it is, depending on, what experts have to be hired, things of that nature. But the only thing that we can do is we can sit here and we have to wait until whatever comes to light. That's the only thing. Like I said with Cassie, y'all have to understand as well. The only reason that these victims have no other way unless they went to the police right then and there and filed criminal charges. The statute of limitations for filing criminal charges is up and over. So the only thing that they will be able to go through the civil route and actually obtain, something of that nature, for their emotional distress, their mental health, pain and suffering. You get that through civil. So we can't fault anybody from saying, or not from saying, from seeking any type of justice. This is the only route that they have unless they filed charges when the event or the incident happened. I don't even care for Jay-Z. I just like weighing the evidence. And that's all it is. That's all it is. This is dismantling of us economically. Facts. Don't agree. They love the money and the lifestyle. They do. They do. But hey, y'all, thank y'all for tapping in. I'm going to probably go live in a couple of minutes. I'm going to run over and see what's going on with DJ Academics. And I'll probably do a video. I probably won't go live, just do a video and see what we got, because that man be talking about everybody else's cases but his. And I'll be so confused. All right. But definitely tell me what y'all think about Judge Torres' letter to Alex Spiro and Jay-Z. She humbled them real quick, baby. I mean, real quick. Dropped the mic and went on by her vacation. That's what she did. But y'all tell me what y'all think in the comments below. Don't forget to like, share, and subscribe. Until then, I will see y'all later. Be blessed. Bye.